Ladies and gentlemen, I'm very pleased to announce a very special conference that we have because of the professional background of the speaker of today. Very seldom we have somebody who is trained in two disciplines as Grischka Petri is. As a jurist on the one side, but not just a philosopher, a theory of law. No, very concretely judicial problems, dogmatic problems that he dealt with, and where he made also seminars and introductions to civil law, if I remember well, some 15 years ago, and so forth. But I was not your student at that time. Furthermore, in a somehow parallel way, studies in the history of art, and not just the history of those jurists who were also interested in art, but completely separated. So if we look for a model case of the separation of spheres, he would be the one to represent just the separation. But the separation doesn't make sense if and when it is not brought together. If it is possible to profit from synergetic effects, as we call it, it is a great possibility. But how to do this? What are the topics? What are the lines of overarching interests, of cross-cutting cleavages and cross-cutting similarities, simultaneities, and so forth? This is a question one has to talk about, and one way that we discussed with Thomas Dreyer, that we discussed with Gian Maria Ajani from Turin, is to look at those judicial fields that promise to protect the life of the artist, the work of the artist, to protect even the concept of art as such, as we could learn when discussing with Gian Maria Ajani, because by way of looking at the problems of copyright, we got another access to problems of modern art, of conceptual art, of the processes, the role of processes, but how to inscribe legal normativity into those processes. That's a great problem. But if you pose it, and if you raise the question, you are much closer to the art. So what our experience is to learn about the art by way of having a judicial gaze at the art, and perhaps also to learn about law. So to go in both directions was the fascinating point. So then what is part of the normal presentation is to show the books. Normally we should weight it in kilos, and this is a kilo, certainly kilo and 200, I would say, nearly. And this is Arrangement in Business, the Art Markets and the Career of James McNeill Whistler. I don't know whether Whistler is very much familiar to you. You know Whistler? But you have seen the Frick collection in New York. You have seen it? Yes or no? If you have seen it, you have seen the Whistlers. 4 Whistlers, wonderful Whistlers, or 5. Sorry, he's always, it's really horrible. He's correcting even such a minor, not a real mistake. No, but I think the 5th one is not a real Whistler. That's my proposition. Okay, we have to talk about this. It's a good one. And also another book I would like to, so this is of course a way to look at an artist. I would say it is the most dandy artist of the late 19th century, one could say. You would agree? Absolutely. In a way. So that's really his point. And to make something in comparison with Ruskin and others, this is just in the tradition of art history, but in a way that is also very innovative, at least as my reading has proved for myself. Another book that I would also like to recommend is Eklektizismus und eklektische Verfahren in der Kunst. You know, this is really the most horrible thing you can ever receive in a comment on your work. This is eclectic, you know. But he's doing a eulogy of eclecticism, and for very good reasons. So we could expect now a kind of an eclecticistic talk, but reflected in a systematic way, as we know. So the floor is yours.
Thank you. Thank you. Dear Vanagappa, you never cease to surprise me. So indeed, this is going to be quite eclectic, maybe. And dear fellows, friends and colleagues, it's a great pleasure and privilege to be here to come back to the Käte Hamburger colleague tonight or this evening. And it has been a pleasure to work here as a fellow this winter, which is why I would like to say thank you to you and your exceptional team. This institution, if I may say so, and its activities are an outstanding achievement, and I continue to be very impressed. It's a think tank where you don't feel like swimming in a tank, but rather like in a swimming pool, something very pleasant. And I invite you to paddle around with me in the history of copyright tonight. I tried to finish in time for the semi-finals of the German Football Cup, which are probably far more important than copyright. The subtitle of my talk tonight points at a deeply rooted divergence between the world of the artist as seen by himself and the legal role of the author, which is, to different degrees, as we shall see, vital to the concept of modern copyright. So it's this kind of alienation I would like to refer to, and not a spectacular extraterrestrial intervention. So off with the aliens. Instead, my paper will focus on three aspects of copyright culture. I will not offer solutions, but present historic examples, which I have found significant. Here we have the eclectic approach. And I'm aware that there may be other, perhaps equally suitable examples from other disciplines, in particular literature, music maybe. However, I will focus on the visual arts. As usual, I have changed this talk considerably while working on it, which is why I would also like to change its subtitle to a more modest announcement of some observations from the margins of concept of copyright. In the first part, I will investigate the relationship between copyright and material culture in the field of copyright. Part 2 will highlight the role of the author. And finally, I will ask some questions about the survival of both concepts in contemporary art and in today's copyright system. And I will suggest that there is a resilience of the material in the visual arts, even in our dematerialized times. Let us start with part 1, copyright as material culture. Most copyright histories tell their story under the terms and conditions of the book trade, striding through the Gutenberg galaxy with a view to texts mainly. But told from the perspective of the visual artist, it would sometimes look different. There's not the time to tell the story tonight, but one big difference is important enough to merit a closer look. While a book is an object, the printed text, which is the copyright-protected commodity, is not, in general. In fact, its theoretical immateriality contributed to the evolution of the term intellectual property, the German Immaterialgüter, or immaterial goods. So from the outset, however, artistic production, the visual arts, were material. And while our copyright laws acknowledge this by definition of the work of art, this has also caused confusion. Almost 1,500 years ago, legend reports an Irish case which has repeatedly been included in copyright history textbooks. Finian versus Columbkill, later known as Saint Columba. Columbkill was an ambitious young monk, and he studied the script under Saint Finian in Moville in Northern Ireland. According to one version of the legend, Finian brought the first copy of the Vulgata to Ireland, and he lent it to Columbkill for him to study. As students today, he believed in the expression, well copied is half studied, and started to copy it secretly at night. He was found out, and Finian felt angry that someone he trusted could have done such a thing. And behind his back, he asked Columbkill that he should give him the copy he had made when it was finished. And this is the copy traditionally identified with that book, but it's just a very old tradition and we don't have any proof of that. Columbkill, however, was of the opinion that his copy would serve to spread Christian beliefs in Ireland and that he was entitled to copy the book and to keep it. And the matter was referred for arbitration to the High King of Ireland, Diarmaid, and his court. Columbkill finished his pleadings, arguing, I haven't used up Finian's book by copying it. He still has the original, and that original is none the worse for my having copied it. Nor has it decreased in value because I made a transcript of it. The knowledge in books should be available to anybody who wants to read them and has the skills or is worthy to do so. The king, as the judge, was not impressed. He said, I don't know where you get your fancy new ideas about people's property. Wise men have always described the copy of a book as a child book. This implies that someone who owns the parent book also owns the child book. To every cow its calf, to every book its child book. And the child book, the copy, belongs to Finian. The ruling arguably triggered a series of events that led to the slaughter of 3,000 people at Cool-Drummond in the shadow of Ben Polden, you see here, a place I desperately want to go to. It seems a nice place. And Columbkill became Saint Columba and emigrated to Scotland, where he founded the famous monastery of Iona. The case is not without significance for contemporary copyright law. In a more recent case, EMI Records Ireland and others versus Icon Altidi, the judge of the Irish High Court made reference to Saint Columba. Unfortunately, he got it wrong and attributed the quotation to the wrong man. What is more important is that the case, although referring to the problem of copying a book, was not a copyright case at all. Of course, copyright didn't exist, but the contents of the book were not part of the problem. Instead, the issue at stake was a question of materials, as only some few selected historians have pointed out so far. It's worth reminding ourselves that producing a manuscript in the early Middle Ages meant a massive investment. To produce a book, a scriptorium needed expensive materials such as gold, color pigments, vellum, because paper didn't yet exist in Europe. Indeed, the term vellum is derived from the Latin word vitulinum, meaning made from calf. So the king's comparison of a book's copy with a calf suddenly reveals a double meaning. The question of the ownership of a manuscript and of a painted tablet, a wooden tablet, not an iPad, was an ancient problem in law schools known as the problem of the tabula picta. If a painter painted a wooden tablet that belonged to someone else, who was then the owner of the painted tablet? The painter or the owner of the tablet? In his Institutes, Gaius offered his own solution, which we can read here, or soon. And I know that some of you speak and think Latin fluently. For the rest of us, there is fish. So, according to Gaius, it is settled that whatever anyone has written on my paper, or parchment, rather, even in letters of gold, is mine, because the letters are merely accessory to the paper or parchment. In other words, ownership of the parchment prevails regardless of what has been written on it, or how, or with which kind of materials. The Irish verdict was in line with this solution. Interestingly, however, Guy's reported a different solution for paintings. If, however, anyone paints anything on a tablet belonging to me, as, for instance, a portrait, the contrary rule is adopted, for it is said that the tablet is accessory to the painting, but a good reason for this difference hardly exists. Future scholars have attempted to find such a good reason for a solution which was regarded a classic problem for law schools. Books have been written on the subject. I will not dwell here for long, but will only want to point out some selected opinions on the problem. In the Corpus Juris Civilis, it said, Justinian, pictures, however, do not usually constitute part of the tablets on which they are painted, as letters do of the papyrus and parchment on which they are written. But, on the other hand, it has been decided that the tablet is accessory to the painting. We say, however, that an action to recover the tablet will probably lie in favour of him who painted it, against the owner, but he should tender him the value of the tablet, a piece of wood. That means that only a few years before the Battle of the Book in Ireland, remember, 3,000 days, the painter would have acquired ownership of the tablet. It's argued that it would be ridiculous if a famous artist would not be the owner of his paintings. Apparently, scribes were not taken for artists in this sense of the law, or at least in the sense of this legal idea. Other authors have commented on that, and it becomes clear that over the centuries, scholars didn't cease to make new propositions and solutions to the problem. They came forward with considerations that took into account artistic values. A dignified subject made a difference, a higher value, whatever that means, even material value, that's an argument that we've heard, or the fact that a painting was more than mere decoration and served a higher purpose. All these were arguments that were put into the possible solution of the problem of the tabula picta. It's interesting because seemingly immaterial elements enter the scene here and shape the question of property. Put even shorter, an intellectual act can change material ownership, like painting something, long before the advent of copyright law. The stories of the Battle of the Book and of the tabula picta remind us that all visible images are materially conveyed. It's a question of the material reception rather than the material production. This may have consequences for a copyright that wants to protect these images. What is more, the seemingly restricted concept of modern copyright, which relies on ideas of an artwork taking material form, may not be so restricted at all, but perhaps very well suited for its purpose. I will come back to these questions in the final part of this talk. The look through the periscope of history into the oceans of the past can also give us an idea why it's still complicated to disentangle questions of ownership and copyright. To get access to a work of art, to copy it, can be more than just a question of intellectual property. In the world of art, it very often means a lot of obstacles, practical obstacles of property, material property, ownership, gatekeepers, even for works that are safely in the public domain. That is different for texts, and the law hasn't always found a satisfying solution to this problem in the area of the visual arts, which is a problem of the relationship between law and culture. We have seen that some theories of the tabula picta have put the artist at the forefront of considerations. Interestingly, the ancient legal scholars have not questioned the phenomenon of an artist's fame when arguing that a picture made by a famous artist can change the ownership of the underlying tablet. This highlights the social and cultural capital involved in the role of the artist as author, to borrow the terminology employed by Pierre Bourdieu. And it is exactly this kind of capital that copyright regulations endeavor to protect. In a sense, the next part of my talk will deal with copyright law as cultural capital. For a long time, the Middle Ages have been regarded as ignorant of the role of the author or the artist. Common opinion still is that the history of art is the history of an ongoing individualization of the artist and of an increasingly autonomous art. Recent, and no longer that recent, scholarship has shown that this narrative needs a good portion of reconsideration and more precision. Tonight, we don't have the time to reiterate all the examples of medieval artists who have left us a statement of their authorship on their work, but I can assure you that there are more than we think of, and I will show you but a few examples. On this probably Italian codex dating from the early 7th century, which says around the time of the Battle of the Book in Ireland, remember, 3000 deaths, describe Signed work in the intersection of the cross, Ego Valerianus Stripsi. I, Valerian, have written this. Some 400 years later, Bishop Bernward stated on his silver crucifix that he had made it. Bernwardus presulficit hoc. And it's again a very prominent statement at the top of the object. Another famous example is the signature of the sculptor Gislebertus in the Cathedral of Saint-Lazare in Autun. Placed just below the Last Judgment, the signature makes a claim for that very occasion. Please judge me for my works. This signature works as a testimony to make a case for the artist on the day of the final judgment, and as such, it even has a legal connotation, if a transcendental one. However, you may ask, this is all fine, but where's the copyright law in this? Indeed, copyright law is not only about ascertaining the authorship of the artist, I made this, but also about banning other artists from remaking it or exploiting it. You may not make this again. I made it. In this legal sense, authorship as a legal concept gained, I try to put it cautiously, gained momentum with Albrecht Dürer. His artistic ego would have been big enough for at least two artists. As this self-portrait demonstrates, in it Dürer presents himself in the pose and posture of Christ. Also, he's wearing a coat with a furred collar, which only the higher circles of urban aristocracy were legally allowed to wear at a show. So the self-portrait is an act of self-nobilitation and represents a culmination point in the history of self-portraits and signatures. Dürer moved in humanist circles and was very conscious of his role as a creator. His friend, Konrad Keltis, was one of the first authors in the German Empire who obtained an imperial privilege for his edition of Roswitha of Gandesheim's writings. Similarly, when Dürer published some of his print series in book form in 1511, he obtained privileges which were to protect his investments. The role of the artist as author is changing at that particular moment in history because the advent of the Gutenberg galaxy has not only changed here the way how texts were read and distributed, but also created a new market for pictures in the shape of prints. These became merchandise goods very quickly, and Dürer belonged to the probably first generation of artists who fully comprehended and exploited the print's commercial potential. The material component of artworks was now brought to another level. This reflects the easier reproduction of images in its double implication. It was easier for pirates to exploit a print by copying it, and it was easier for artists to distribute their own productions. In an evolving market, it didn't take long before artists called to the law for the law to protect them. Dürer was one of the first. The colophon of the last page of his Life of the Virgin is identical to Dürer's other book publications in that regard. The typography is slightly different. This concerns also the Passion of Christ, the Apocalypse. It's written in Latin, so again we let our Babel fish out, and the translation reads, printed at Nuremberg by the painter Albrecht Dürer in the year 1521. Beware, your envious thieves of the work and invention of others. Keep your thoughtless hands from these works of ours. We have received a privilege from the famous emperor of Rome, Maximilian, that no one shall dare to print these works in spurious forms, nor sell such prints within the boundaries of the empire. And if you commit such a crime out of contempt or avarice, be assured that not only your goods will be confiscated, but you will also have to expect the highest punishment. I don't dare to imagine what that means. Indeed, there exists a judicial decision by the City Council of Nuremberg, dated 1511, same year, that seems to defend this privilege. It declares that a foreign print seller was not allowed to sell unauthorized Dürer prints with the famous monogram of the artist, and that this monogram had to be erased from that prints. In the second edition of his Lives of the Artist, published in 1568, Giorgio Vasari sets this story in Venice, which, however, is an invention around the famous engravings by Marcantonio Raimondi, who copied Dürer's woodcuts in another medium. In Vasari's version of the story, Dürer travels to Venice to bring Marcantonio to court, and the Signoria decides that the copies may only be sold without Dürer's equally copied monogram. The story is fictional, but based on true events, namely the City Council judgment from Nuremberg. Later, Raimondi, the workshop of Raphael, and Dürer even collaborated to publish an Italian edition of Dürer's Small Passion series. It's an important juncture in media history, art history, and copyright history. The new technologies required new rules for the art market, and Dürer stood at the forefront to formulate these rules by artistic self-consciousness. It indicates a new age of proto-copyright for the visual arts. However, the artist's sense of rules was ahead of his time. In his invective against potential pirates, he mentioned both labor and genius as driving forces and qualities of his art. The imitating copyist would take advantage of both. The two terms highlight the double nature of a work of art, its materiality and its intellectual content. It would take some time to translate this understanding of cultural capital into legal currency. I will not attempt to retell the entire history of copyright here, but instead focus on two, perhaps 2.5 particular moments before embarking on the third and final part. An important episode is the so-called Hogarth Act. Hogarth was a successful engraver and painter, and his satirical series were highly acclaimed, very popular, and very often published in pirated editions, of which we can see a rather bad example here. And since 1710, copyright law in the United Kingdom, in the form of the so-called Act of Anne, protected texts or books for a period of 14 years. And now Hogarth wanted the same for pictures and prints. And he was not only successful in selling his prints, but also in lobbying Parliament. And in 1735, the Act for the Encouragement of the Arts of Designing, Engraving, and Etching historical and other prints, by vesting the properties thereof in the inventors and engravers during the time therein mentioned, as it was officially called. No wonder that people just called it the Hogarth Act, much shorter. This act came into force. Its focus lay on the print as a commodity and put the author in the central position, the driver's seat if you want to. And just as a footnote, if we took into account the difference between publishers and artist authors, this talk would become even more unmaneuverable. So both Dürer and Hogarth to conclude this footnote, were mostly publishers of their own prints. In France, developments took a different direction at the end of the 18th century. In summing up a part of the current intellectual discourse of the past 20 or so years, the revolutionary decree of 1793, focused on the author as creative genius and protected works that were the product of such a genius. I will not go into the details of the different copyright cultures of Britain and France here, and of its affiliations in American and its conflations in German law. This would be worth a talk of its own. But what I would like to point out here is that the introduction of copyright laws did not necessarily solve the underlying problem that had already haunted Albrecht Dürer, as artists in the West operate under the market paradigm of innovation, and that includes technical innovation. So this is a huge leap forward, so when photography had developed into a usable medium, also reproductive medium, it immediately became a problem for the relatively young copyright laws. In France, courts had to decide whether photographs were products of a genius in the sense of the law of 1793, which of course is before photography was invented. And in a famous case, the photographers Meyer and Pierson from Paris brought the publisher of a pirated edition of their famous carte de visite photographs before the Tribunal Correctionnel de la Seine, seeking an action for contrefaçon. The case took several complicated turns before finally the Cour de Cassation decided that a photograph could be the product of a genius, in the sense of the law of 1793, but that it was for the courts to decide this on a case-by-case basis. This was not what photographers had wanted, and in Britain the legislation simply bypassed the problem, as its laws were not based on the assumption of a creative act, but on the right to copy and to reproduce works of art, literary and other. And perhaps the distinction, this will be the only more occasion that I will mention this, the distinction between the Anglo-American copyright system and the continental system of authors' rights is best visible in this historical moment of 1862, the introduction of the Fine Arts Copyright Act in the United Kingdom. The Act simply protected photographs irrespective of the status of the image as art or industry. So all photographs were protected. So if we want to look at law as culture, the legal question of photography as a case of copyright became a question of culture for the French courts, whereas the British Copyright Act decided to exclude all the cultural problems of the artful status of photographs. So it was culture as law versus law without culture, in a very oversimplifying way. In another way, history was about to repeat itself. Around 1500, Dürer had used a new technology to invent and produce works of art. He sought respect and recognition for his work, not far from our modern concepts of moral rights of the author, and an effective protection of his investment against counterfeiters. He obtained a privilege. Hogarth updated this constellation to a new legal instrument. In a way, he obtained a written law, but the effects were further reaching than his own individual case. And around 1850, photographers found themselves in a similar situation. They used a new technology, as Dürer had, but they were not recognized as artists and did not automatically enjoy copyright protection. In France, the reliance on the individual court case reiterated the application for a privilege. In a way, it was just a case-by-case thing if you would get protection for your photographs. And in the UK, the legislator eliminated the problem for the time being before it was reintroduced in later copyright acts. The media of public debate had changed also since 1500, and the arguments were exchanged in pamphlets before courts, in parliaments, and within artists' organizations such as academies and societies. Interestingly, But not surprisingly, dealers and photographic publishers eagerly staked their claims in the debate, and a considerable number of pamphlets were published to support the case of photography. Of course, a roughly equal number of pamphlets were published to support the case against photography, but we have to move on. Common criticism questioned whether photography was a product of labor et ingenium, as Dürer had meant it, and Hogarth and others had established it in the sense of the law. But photography was seen as a medium that eliminated the author, and it was also seen as a medium that partly eliminated its materiality. So this dual elimination has become somewhat of a postmodernist standard concept. Some cornerstones of this evolution have been presented to us last month in Gian Maria Adjani's wonderful talk about the challenge of contemporary art for classic law, which means that I can keep this very short. And while I, as probably most of us here tonight, agree that we live in an age of increasing dematerialization, I suspect that the visual arts have inherited a kind of material resilience which has to do with its conditions of perception. We cannot see the invisible, although we have learned to make visible some parts of the invisible. At least we believe that we can, and perhaps we only have learned to visualize parts of the invisible. One of the classic inventors of the unauthored work of art is Marcel Duchamp, who introduced the concept of the ready-made to art almost exactly 100 years ago. The most prominent, perhaps, is Fountain, a urinal which was anonymously sent as a sculpture to an art exhibition in New York, consequently rejected, which caused Duchamp to stand down from his seat in the jury of that exhibition, and all what is left of this original urinal is this photograph by Alfred Stieglitz. Recent intelligence suggests that it wasn't even Duchamp's idea to send the urinal to the exhibition, but the German émigré Elsa von Freytag-Loringhofen, which would make Fountain not only one of the first ready-made works of art, but also a piece of appropriation art, if one wants to be kind, or outright piracy, if one doesn't. In the mid-1960s, Duchamp was approached by the Milan art dealer Arturo Schwarz, who suggested to publish an edition of replicas of the old ready-mades, among them Fountain. These replicas were all handmade according to old photographs and received Duchamp's approval, who signed them. To be true, these objects are no longer ready-mades, but replicas or copies of ready-mades. One could also, one is tempted to call them originals. With these replicas, Duchamp annihilated the grand gesture of the eliminated author and became an old master. The declared inventor of unauthored art reinstated the author at the very moment when other artists tried to pursue the original idea of an unauthored work of art. Now, was this a case of fatal attraction of the material object? The American artist Donald Judd had sold some of his art concepts to the Italian collector Count Panza di Blu. It seemed like the perfect idea to sell an idea for a work of art as a kind of construction manual. However, the collector decided to follow the instructions and ordered his cubes, the cubes here that were subject of this contract, to be assembled in the workshop of his trust. Judd fumed and published a series of articles in 1990 in which he accused Panza of breach of contract and forgery, and that he was, it's not quoted. Before the conflict, however, could be settled, Judd died. The case shows that even an idea for an object incorporates the potential of its materialization, and we sometimes tend to ignore it. So, instead of a tabula picta, do we have a cubus vignatus here, a problem? The problem re-emerges in this shape. Whose is the object, and why can't we get rid of the object anyway? In 1985, the French philosopher Jean-François Lyotard curated an exhibition at the Centre Pompidou entitled Les Immatériaux, in which he called for attention to a multitude of developments towards the immaterial work without an author. Art was seen as a piece of privileged information, a part maybe of communication at large, which it certainly is, but it is more than that, and two recent French court cases have dealt with the problem and highlight some aspects, which will serve as the concluding episode. One case involved our good old friend Marcel Duchamp and a French performance artist, Pierre Pinoncelli, who in 1993 reinstated a fountain replica to the utilitarian function of its lost original when he peed into it at an exhibition in Nîmes before hitting it with a hammer. He literally and materially took the piss out of Duchamp's fountain. Early in 2006, when the same replica, repaired, restored, was on show again at the Centre Pompidou, he hammered it again. The Tribunal des Grandes Instances de Paris condemned Pinoncelli to 3 months in prison on probation, 14,000 euros reparation costs, and damages of 200,000 euros. He defended himself by arguing that fountain was not a work of art at all, at least not anything original, and this is why the courts had to decide upon this delicate question. However, the Cour d'appel abstained from deciding this question, avoiding the issue by focusing on questions of admissibility. Apparently, there remains an insecurity that prevents even an obiter dictum in the matter, literally, matter. The other famous recent case is the Affaire Paradis. The German-born and Paris-based artist Jakob Gautel had placed the word paradis above the door of the toilets of the alcoholics' dormitory of the Hôpital de Ville-Évrard. In some ways, we have heard of golden letters before when dealing with the tabula picta problem and parchments and scribes and the Battle of Books, remember, 3,000 deaths. Here, the photographer Bettina Reims had used the space for her own series of photographs after biblical iconography, and Paradis served as the background for a triptych of Eve and the Virgin. You can see a detail here, one of the wings. The case was widely debated in France, and the question was asked whether it was sufficient to place a word in an unusual place to qualify as a work of art. Was this not too close to protecting an idea without an original form? In its final decision, the Cour de Cassation in 2008 ruled that it was not, and that the work consisted of more than just applying the word paradis above a door, namely that the conceptual approach of the artist had been formally expressed in an original material realization. This contemporary jurisdiction seems to acknowledge both that contemporary artworks with a reduced materiality and ideas and context, but also that there remains a material expression. In a way, the attention is about to be shifted from the material production to the material conditions of perception. In terms of our understanding of art as material communication, I agree that this might be an appropriate approach, but this is open to tonight's debate. What I found astonishing is that in the case of Gautel versus Reims, we are debating the same old problems of the tabula picta in some ways, now in the guise of the murus pictus. The Swiss artist Harald Nägeli was mainly active in the late 1970s in Zurich. His career would be worth another evening, but it will be enough to tell you that he was arrested and convicted by the court of Zurich and served his sentence in prison in 1984. But 10 years later, even the authorities of Zurich at last recognized his graffiti as art. The city even restored one of the very few of his surviving works in Zurich, here, Undine. When the building of the Zurich University was renovated between 1995 2005 and 2004, the graffiti was considered valuable art by the building department and even covered to protect it for the duration of the work. And it was also restored, whereas neighboring graffiti works were eliminated. The constellation prompts some final questions about the ownership of the image. If deemed a work of art, Nägeli's works would be copyright protected, or are, and the artist would enjoy all moral or mural rights attached to do that, including the right to be identified as the author and the right to object to derogatory treatment of the work. What such a treatment can consist of is again open to debate. In another case of the Murus Pictus, the well-known street artist known as Banksy created a mural in Wood Green in northern London in 2012 to raise some issues connected with the imminent London Olympics, Queen's Diamond Jubilee, and sweatshops in Asia. The mural depicts a boy hunched over a sewing machine making Union Jack bunting. Not even a year later, Wood Green Investments, the company owning the building on which it was found, had taken down the mural, and it was offered on auction in Miami. After protests, it was withdrawn, but later auctioned off at Covent Garden for £700,000, or roughly the equivalent of $1.1 million. The mural's current whereabouts are unknown. Banksy has not been accused for vandalism, as Nägeli was, which means that we still have not left the age of privilege behind us, and authorship in public media needs a satisfying reassessment beyond material ownership. It could be argued that the auctioning of slave labor is a derogatory treatment of a Banksy under the ideas of the author, but the laws of the Murus Pictus will have to change for that. Indeed, for some problems of copyright, we will have to ask ourselves in what kind of culture we want to live in. And I will borrow my last remark from Elvis, from a song about a mistrusting and dysfunctional relationship, which is our relationship with copyright. We can't build our dreams on suspicious minds. Thank you.